pretty good.
Two minutes.
My problem is that I'm doing really well.
Are we expecting our colleagues this evening? No, one of them.
There's here. I'm not sure. I haven't heard about her from Trish.
Okay.
Yeah. She usually texts us, so
Yeah.
she'll probably be a few minutes late.
So just out of curiosity, what problems were you guys supposed to prepare? Like, I didn't bring an outline or something.
I don't think there was a specific.
There's about 75 in chapter 5, 75 problems.
Yeah. We didn't give you a specific one?
No.
Maybe that's why I don't remember which specific ones you were supposed to do.
You're supposed to read all of chapter 5.
Yeah.
All right, well, that sounds like fun. You could have stopped at the impeachment stuff, but sorry. Yeah, I know. I don't know. Anyway. All right. Okay, so we don't have Professor Nolan because he decided to go to Needles. How depressing is it that you would rather go to Needles than hang out here? And you got me the day after I got a tooth removed, so I'm not exactly planning to go to 9 o'clock tonight because I got to get home and so I got to take my pain medication. Sorry. Anyway, okay, so character evidence, right? Anybody tell us what character evidence is? And where do we get the definition?
404.
All right, does Rule 404 define character evidence? You know it's good when it starts out with prohibited uses, right? Wait a minute. When they start out not telling you how you can use it, but how you can't use it. So basically, 404 doesn't tell us what it is. Nice. So let's talk about what it is for a little bit. Can they give me an example of what they think character evidence is? Hello.
Thank you.
Thank you. All right, everybody's here. So, character evidence, anybody, what is it? Give me an example. Come on, you guys, you read the chapter. It's really that hard.
It's more than characteristics and tendencies.
Okay, so what is it?
It's like traits.
Yeah, it's like, yes, it is something about, you know, how's an honest person, Pete's careful in driving, whatever. It's more than just that. It's certainly things about moral character, like honesty, integrity, whatever. But it's also things like what you usually do or what you always do, right? That have got nothing to do with being morally right, wrong, careful, whatever. Including things like shyness and fondness for cats and whatever. So it certainly includes moral character, if you will, but it's also more than that, right? Patterns of behavior, whether they involve morality or not. The other point to make about this is, besides the fact that it's not defined in the rules, is there are things that you always do that are called habits, right? And there are things that you usually do or often do or pretty much always do. Those are tendencies. And the difference between habits and tendencies is, guess what? One's admissible. One's not. So it's kind of important to be able to distinguish them. The final point in point 2 of our outline is the definition includes sort of everything of your character, right? You know, you're an honest person or a good person or whatever, but also individual traits like you're reckless or you're violent. Character isn't specific to a particular time and place. It's developed over time, which means it's not like I saw Hal, stick a gun in somebody's face and take their property. It's more something that's developed over time and that no one witness can see everything of. So when you're examining a witness, you don't get to say, tell us the character of so-and-so. You got to prove it indirectly. And there are three different ways of doing it. One is specific acts. Tell us some examples, specific acts that this person did or didn't do, so the jury can conclude that that trait exists. Or give me your personal opinion about whether this person is honest or likes cats or whatever. And finally, not your personal opinion, not specific things that you saw the person say or do, but reputation. What people in the community think of you. So three different things: specific acts, personal opinion based on what you've seen and heard, and reputation. What does the community think about you? So character evidence is presumptively inadmissible, right? So we start with you can't admit it because we're not litigating about what somebody is like, but what they did or didn't do. And if you just tell me that somebody is a good person, that might be helpful in trying to figure out what they did or didn't do on a particular occasion. But the real fact that we're litigating, what did they do or not do on a particular time? So, character evidence is inadmissible when it's offered to prove that the person behaved in accordance with their character on a particular occasion. So, if the defendant has a tendency to drive fast or aggressively over the speed limit, you can't introduce that to say, on October 9 at 6:05 p.m., the defendant was driving aggressively and over the speed limit, right? Make sense? Okay. But, and by the way, at the start, this rule is like a lot of rules where you have a general rule, right? Here we don't have a definition, but usually there's a definition, a general rule, and then exceptions. So here there are some exceptions to the general rule that you don't get to offer character evidence to prove that someone acted a particular way on a particular occasion. The first, when character is an issue. So when character itself is an issue, then of course you can introduce that. And what are some examples of when you can introduce that? We list 7 of them in a case for defamation of character. Well, it'd be hard to prove up a defamation case if you couldn't offer evidence that your character was a certain way, and that wasn't it, what that person said about you. Parental fitness and custody cases, of course, right? You want parents to be of good character. Negligent hiring of an employee who turned out to have bad character. Obviously, the employee's bad character is something that you're going to want to be able to litigate about, and so you can introduce evidence about it. Whether the decedent was a good provider in a wrongful death case, and again, that's only in certain states. Habitual offender statutes, that's like 3 strike stuff. RICO, which requires proof of a pattern of racketeering activity, so you can say, well, this person is a gangster because they have a reputation for being a gangster or do gangster things. And finally, where the defense has raised entrapment, you can show that the defendant, where the defense says, I was entrapped into doing this, you get to show that the defendant had a propensity to commit the crime. They were likely to do the crime, which obviously involves some character. So those are the exceptions to the rule that fall under the category of the person's character is actually an issue. It is an issue in the litigation. All right, second exception. So character evidence isn't admissible to prove the defendant acted a certain way or to prove that someone acted a certain way in a certain situation. But if character is at issue, you can offer character evidence. We just went through the examples. Second exception, you can use character evidence when characters offer to prove something other than the tendency to engage in that behavior. Now you might say that's not really an exception, right? Because then you're not offering character evidence at all. You're offering evidence of something else. So maybe that's a better way to think of it. But you might think of it as an exception because you're offering evidence that sure looks a lot like character, right? For example, you can't say the defendant's written bad checks on 17 other occasions, so he must have written a bad check on October 10. But if the defense says that's not my handwriting on that check, the prosecution can bring in a bunch of other bad checks and say, well, that was your handwriting on this one, on this one, on this one, on this one, and it's not your handwriting on that one? Okay. Now, obviously you could use any writing samples to prove that. If you happen to pick a bunch of bad checks, which is what the DA would do, well, how convenient, right, for the district attorney. Or if the defendant claims he didn't know there were no funds in the account, you could show, hey, he's written checks with insufficient funds like half a dozen times earlier that week. So yeah, he knew there weren't. And again, it's not going to carry, right? It's not going to show he has a tendency to write bad checks or he's a dishonest person or whatever. It's to show he knew he didn't have funds in the account. So first exception, where character's at issue. Second exception really isn't offering character evidence. It's offering evidence that sounds like character evidence for something else, or showing something other than the person had a tendency to act that way. And again, usually this is offered by the prosecution and often in rebuttal in response to what the defense is claiming. Third, Rule 404A, several exceptions that relate to criminal cases, okay? So criminal cases, right? Keep that in mind. The defendant can prove his own good character, both a general trait, he's a good person, or a specific trait, he's an honest person, or he doesn't write bad checks or whatever. And the state, once the defendant does that, can respond with similar evidence. So if the defendant says, I want to offer evidence that I'm an honest person, then after that, the prosecution offer evidence that shows the defendant is a dishonest person. The defendant may prove character traits of a victim, right? And if the defendant does that, the victim is hot-headed, flies off the handle, tends to try to provoke others, is violent, whatever. The state can respond two different ways. One, of course, the state can say, no, the victim wasn't that way. The victim was a good person, a modest person, a shy person, a quiet person, not a violent person, not flying off the handle, not causing problems. So you can respond in kind and say, no, the victim's character wasn't that way at all. Or you can say, oh yeah, well, you were just as bad, right? You say the victim had a temper and flew off the handle. Well, guess what? You, defendant, also have a temper and tends to fly off the handle, okay? So this is responding to what the defendant has raised again, right? So first type, the defendant offers evidence of his own good character. The prosecution can say, no, you don't have that good character, and here's proof. The defendant tries to prove the victim's character. You can respond with, no, the victim's character wasn't that way. Victim was a good guy. Oh, and by the way, if you say the victim was bad, you're just as bad. So you can offer two different types of evidence, responding to the victim was such and such, the victim had this type of character, and if the victim was bad, you were worse. As the outline says, this usually comes up in self-defense cases in which character for violence is often to show who struck first, right? The defendant says, hey, it wasn't me, it was the victim, he's a hothead, he's got a reputation for violence, and so he started it, and then the prosecution can say, oh yeah, he wasn't a hothead, and by the way, you're even more of a hothead, defendant. If the victim has died, right, so the victim's dead, the prosecution can prove that he or she was a peaceful person but only in response to a claim of self-defense, right? So you don't get to show, hey, the victim was a really, gentle person, unless the defendant's raised the issue of, hey, I acted in self-defense. If so, what do you get to do? You get to offer evidence that the victim was in fact a peaceful, docile person, right? Okay, and finally, well, yeah, that was it. And then, again, these are criminal exceptions. Right? In some states, these apply in intentional court cases, like assault and battery or something, if the underlying conduct is criminal. Final exception, Rule 404A3 has an exception for bad character of a witness regarding truthfulness. That's to impeach the testimony of a witness and basically say, you got a character for being a lying sack. We're not really going to talk about that, but we'll deal with, when we deal with impeachment, we'll deal with that kind of character evidence. Now, just because you're able to say, hey, there's an exception to the general rule of inadmissibility, doesn't mean that you always get it in, because what's one thing that's going to come up? 403, right? Just like we talked about last week. You've got the substantive rule, but you've also got Rule 403. So you'll be able to say, sure, Your Honor, you can find there is an exception for character evidence that might make it admissible here, but it's going to take too much time, it's going to confuse the jury, or the particular evidence they want has a very low probative value and a really high, that probative value is substantially outweighed by the undue prejudice. Okay? And undue prejudice kind of happens a lot when you start talking about character, because it's what evidence of what somebody was like, not so much what they did. Okay? So just because you got an exception doesn't mean you're going to get it in. Have to do Rule 403, and in general, you can't offer specific act evidence. Even when character evidence is admissible, you have to offer opinion, reputation, or opinion evidence. So what did you think of the person that you knew for so many years, or what did the community think of them? And not specific acts. You can't get into specific acts if character was directly an issue, or when you're cross-examining a character witness. So you got the character witness that the defense calls up there, and you want to cross-examine. You can say, well, would it change your mind if you found out that the defendant on September 27 killed 10 kittens, right, or whatever? And often the character witness says, no. Like, well, really? So it doesn't matter to you that he's a kitten killer? And anyway. If you're offering character evidence about reputation, of course you have to establish that the witness knows enough of the community, or knows enough of the reputation of the community to be able to talk about it. If the person never comes back to town, doesn't really know anybody, how are they supposed to know what the reputation of the victim or the person whose character is an issue had that particular reputation? And separately, if you're going to offer opinion evidence, right? What did you think of them? You don't get to ask about, just ask about, well, did you know about this? Did you know about that? Did you know about this other? Would it change your mind? You have to establish before you can even get there that the witness knew the defendant or the victim or whatever over a long enough period of time that they would get to know the person's behavioral characteristics in general and have seen specific examples. So, any questions about any of that? Yes.
Your Honor, when say the defense, say you raise the exception, and
What?
say you raise an exception for bringing character evidence in,
Okay.
and the witness is on the stand. You're not allowed to bring in specific acts, but that witness happens to say, yeah, I think that guy's a bad guy because of blah, blah, blah. He did this, this, and this.
Well, first of all, if you're opposing that, you'd object, right? Well, they were doing that. Objection: the witness is offering specific act,
Okay.
right? And move to striking,
Okay.
right? And of course, we just talked about certain circumstances where you could ask specific act, right? Would your opinion change if? Boom, boom, boom. and what you're asking about are almost all the specific acts. But yeah, you would need to interrupt the witness.
Okay.
If the question didn't call, of course, if the question, could you give us some examples of what specific acts you've seen? Well, objection, right? But if the question didn't call for it and the witness just started giving them, you have to interrupt the witness and object to it and move to strike anything that had already come out. Make sense?
Yep.
But that's only indirect.
No, that could be on cross, right?
Across.
If it wasn't proper to introduce a specific act, and it's not always, right?
Right.
So either way, and of course, if the question doesn't call for it, you can't object to the question. If the answer is giving it anyway, then you have to object to the answer. All right. So let's go back over the rules. Character evidence. Again, no definition. Note that. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with that character or trait. All right? You can't use specific act evidence to prove, or you can't use character evidence to prove that someone did or didn't do something like that on this particular occasion, right? But there are exceptions. Criminal case, a defendant has the right to offer evidence of that the defendant's own trait, and the prosecution can respond to it, rebut it, prove that it's BS. So you can't use it to prove that, you can't use it to say person acted in accordance with their character on this specific occasion unless you're a defendant trying to prove basically that you're not guilty because it's not within your character, right? You don't do that. But if you do that, the prosecution can rebut it with character evidence. Make sense? So it's only in a criminal case, and it's only in a defendant can do it, and the prosecution can respond in kind. Subject to the limitations in Rule 412, a defendant may offer evidence of an alleged victim's trait, and if the evidence is offered, the prosecution may offer evidence to rebut it, so same type of evidence, and may offer evidence of the defendant's same trait. So again, criminal case, the defendant says, I'd like to offer evidence of the victim's trait for violence, aggression, whatever. Okay, fine, assuming that it's otherwise admissible, great. But then the prosecutor can say, well, I'd like to offer some evidence on that character trait too. And these witnesses are going to show that the victim didn't have that trait. And the prosecution also offer evidence of the defendant's trait for the same thing. And of course, in a homicide case, so this is narrowing it down even further, it's not just a criminal case, it's a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. So it has to be a homicide case, and the defense has to offer evidence that the victim was the initial aggressor. The initial aggressor, that's very important, right? So if you have a homicide case, and if the defendant offered evidence, hey, he hit me first, then the prosecution can respond by offering evidence of the defendant's, of the victim's trait of peacefulness, right? There are impeachment rules for witnesses. Again, we're not going to get to them here. Crimes, wrongs, or other acts, okay? Evidence that someone committed a crime or engaged in a wrong or did some other act. Specific act evidence, right? Everybody see that we're talking about specific act evidence? So evidence that you did something wrong, a crime, a wrong, or another act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with that character. Well, wait a minute. Didn't that sound an awful lot like A1? Didn't they already tell us that? Evidence of a person's character is not admissible to prove that they acted in accordance with it. This sounds an awful lot like that, right? They're really emphasizing it for us. So evidence of a person's character, broad, or evidence of a crime, wrong, or other act isn't admissible. So this is kind of a more specific rule for number A1. But again, in a criminal case, you may offer evidence for a different purpose to show that somebody was planning or had intent or motive or an opportunity or knowledge or who the person is or absence of mistake or a lack of accident. But if you do that and the defendant requests, the prosecution must provide reasonable notice of the general nature of the evidence and do so before trial or during trial if the court finds good cause to excuse the lack of pretrial knowledge. So we really, really mean it. You don't get to use evidence of committing a crime or doing a tort or something or another act to prove a person's character in order to show that this was their character and so they acted that way on a particular occasion. We really mean it because we said it above in A1, we're saying it again in B1. But in a criminal case, evidence of, so what is this evidence, what evidence is that? Evidence of a crime, wrong, or other act. So specific act evidence is admissible for another purpose, not to prove that you acted a particular way on a particular occasion, but to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, and so on. And again, if you want to think about that as offering character evidence, great. If you want to think of it as offering evidence that sounds like character evidence, but really isn't, that's okay too, as long as you understand that it's not being offered to prove that that a person acted in a particular way on a particular occasion, right? That you can't do, but you can offer it for other purposes, like knowledge, intent, plan, absence of mistake, etc. Okay? And if the defendant asks, and the defendant's always going to ask, you have to provide reasonable notice of the general nature of the evidence, and you have to do that, you have to offer it before trial, or if the court finds good cause during trial. Okay, so that's Rule 404.
I have a question, Rick.
Yes.
Would you say more often than not, if a prosecutor's trying to get evidence in one way and they're barred by it due to one of these exceptions, there's another exception which they will fall into where they're able to get it in?
I wouldn't say more often than not, but often.
Often.
Right? Because usually you can find a way to say, oh, I'm not offering it for character. I'm just trying to show that they planned the crime, or they had a motive to commit the crime, or whatever, right? But remember, even if you can say, oh, I'm not offering it for that purpose, I'm offering it for this purpose, and this is a lawful purpose. What do you have to deal with next?
403.
403, Your Honor. That's going to, if you're not offering it to prove that they acted this way on this occasion, but you're offering it for this other purpose, that's going to confuse the jury, right? That's an easy one to make. The jury's going to think that it's offered to show that, right? So if you're trying to keep that out, always go to 403. Always. Why wouldn't you? Right? Of course you're going to do that. And we will expect, one way or the other, you to apply that 403 analysis on your exam. Of course you're going to discuss, does it fit within the substantive rule? Is there an exception? But you're going to say, regardless of that, there's a 403 issue. So even if it looks like, if it's inadmissible, you say it might be inadmissible for an additional reason, even if the court found that it was admissible to show plan or absence of a mistake or something. I don't think it does, but even if the court admitted it for that reason, it would still have to do, there'd still be a 403 thing, and the court might excuse it because confusing witnesses, undue prejudice, or confusing issues, undue prejudice, or whatever, right? So it could be a yay more. It's not admissible both because it doesn't meet the substantive rule, and also its prejudicial value or confusing the jury substantially outweighs the probative value. Everybody see how that works, right? It's a yay more argument. By yay more, I mean we win, and we win for another reason too. If you're trying to keep it out, that's why it's yay more, right? We got a great reason, and we got another great reason. But you should, on your exam, if this comes up, regardless of how you conclude that it's admissible or not under the substantive law, you should also say, and there's another objection, right? So even if it were somehow, it's not admissible, right? Maybe you conclude that. It's not admissible, not admissible. It's not admissible under the substantive rule, but it's also not admissible Or there's another objection that might be made, and that's 403, and here's how I analyze that. Probative value, prejudicial effect, undue prejudice, confusing the jury, and here's how I weigh it. The probative value is slight, the prejudice, undue prejudice is high, and so it's not admissible for another reason. Okay, so how do you prove character? 3 ways: specific act, reputation, and opinion. Okay, the way the rule is set up is it first addresses reputation and opinion. So when evidence of a person's character is admissible, we look up here in Rule 404 A and B to see when it's admissible. But when it is admissible, character evidence, you can offer it by reputation or an opinion. And on cross-examination of a character witness, so either way, the court may allow inquiry into specific instances, right? So you can ask the person, well, I understood that you told us that the person has a reputation in the community of being honest. Were you aware that X, right? The person was convicted of bank robbery. If you knew that, you still think that their reputation is good? Or do you know so little about their reputation that you really should be able to talk about it? Or your opinion is they're an honest person, they wouldn't do it. Were you aware that 6 months before they were convicted of robbing a bank? So you can cross-examine using specific instances. You can cross-examine a reputation or opinion character evidence witness. Or when the character trait is an element, you can introduce evidence of specific incidents or specific acts, right? In instances, okay? Now let's shift the subject for a little bit and talk about habit evidence, okay? So what are we not talking about now? We're not talking about reputation. We're not talking about opinion, and we're not talking about acts in a particular way at a particular time. Evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion, the person or organization acted in accordance with a habit or routine practice. Whoa. What did we say about character evidence? You can't use it to prove that somebody acted a certain way on a certain occasion. Unless it's habit evidence or it's a corporation's routine practice, not corporation, organization, it says, so it doesn't have to be a partnership or whatever. If it's our habit that this person does it all the time, in this instance, this is how they always act. This is the corporation's routine practice. So can anybody think of some examples of what somebody does all the time or a corporation's like routine practice? Anybody? It can be really easy.
I think the book said for individuals, like when walking down the stairs, like skipping over
Yep.
one stair,
Okay.
walking 2 stairs at a time.
Showering when they wake up.
Yep. Every morning I take a shower at 6:30. It's what I do. It doesn't matter day of the week, anything. This is what I always do. A corporation's routine practice, that sounds an awful lot like something we'll talk about next semester, which is business records, right? Is something routinely recorded at or near the time of the event, whatever. But a business's routine practice is when we ring up a sale, and by the way, one of our practices is we ring up every sale. We don't ever just give something to somebody. It's always going to be a sale, and regardless of the form of payment, what do? We enter it in the cash register, and we generate a receipt. That's what we do all the time. That is our routine practice. And so, was there a receipt generated for this transaction? No, there wasn't. So what does that mean? There wasn't a transaction to record. So the defendant didn't come in and buy the, whatever, okay? So, contrast habit or routine practice with character evidence. habit or routine practice is we always do it this way. An individual always shaves before he comes downstairs to breakfast, right? A corporation always records a sale, or always has 3 security guards on duty, or pick whatever, right? And if that's something that you always do, this is your routine practice or an individual's habit, then you can introduce evidence of that to prove that on this particular occasion, Thursday morning, October 11, Professor Hop shaved. Why do we know that? Because he does it every day, right? Or every business day, or whatever. Okay? We all get that? It's an individual's habit. They always do this in this situation. Always. Or a corporation's routine practice. Now you can imagine who's going to be the best witness to what an individual does always.
A family member or somebody.
You! What do you do all the time?
Oh, I can tell you.
I'm there all the time, right? I can tell you. It's my habit. I get up and take a shower every goddamn day, right? To paraphrase General Pat. You know that story, right? Supposedly a chaplain was visiting the front lines in Sicily or whatever, sees a Bible next to Patton's bunk and says, "Well, General, do you find time to read the Bible in battle?" He says, "Every goddamn day." So often that'll be the person whose habit or custom is in question, right? Do you always do it? Yep, I always do it. But it's kind of nice to have somebody else say so too, because then, are they making it up? Oh no, their mother came in and said they did it too. Yeah, all right. And note that the federal rule says you don't have to have corroboration and you don't have to have an eyewitness to this, right? You can introduce evidence of habit or routine practice without those things. Okay. We have in Rule 412, in cases involving sex offenses, rules about the victim's sexual behavior or predisposition, and we're honestly not going to get into that here, okay? And there's special rules about similar crimes in child molestation cases and sexual assault cases, and then civil cases about those topics. Okay, so let's dive into some of our stuff. Huh? All right. Why don't we try problem 5-1? Anybody want to do that one? The Ogler. Particularly appropriate given the Me Too stuff and Kavanaugh and all that.
Right, so every time that Ronald Boland passes a woman on the street and he finds attractive, he ogles her and makes lascivious comments in a loud voice. He is a defendant in a sexual harassment civil lawsuit brought against his employer by a female employee. The employee alleges that Boland, her boss, followed her on the job on numerous occasions despite her continued protest. She further alleges that Mullen repeatedly looked at her on the job in a lascivious way, despite her continuing request that he stop eyeing her like a piece of meat. The employee is not, however, someone Mullen is ever ogled on the street, except where otherwise stated. Answer the questions below by consulting only rules 401 and 402.
Okay, so remember 401 and 402?
No, I don't remember 402.
Okay. All right, that's I don't have it here, but that's those are our relevance rules, right? Right?
I thought 104 was relevance.
I didn't read the first book that has it. That's really great.
Oh, yeah, it is. It's relevance.
Yeah. Okay, so this question isn't talking about the rules about character evidence that we just talked about. We're talking about relevance. Okay, And why are we talking about relevance? Because there's always a potential issue with relevance. And it's helpful to look at relevance before we talk about particular characteristics. Okay, so let's do that.
So number one, would evidence of Mullen's behavior in repeatedly ogling numerous women on the street concern his character as defined in everyday usage or something else? Why? I would say yes. It's not talking about the current event at bar, but something he does quite normally. I would say
So it'd be relevant because does it have tendency to show more likely or less likely effect of consequence?
yes.
Yeah, okay. What's our relevance rule? Kind of like that, right?
Yeah, that's to show
Right.
that it's more probable or not to
Yeah.
have occurred.
So the fact that he engaged in this sort of lewd or crude behavior, it probably involves, his prior acts of ogling show that he's someone who's going to like to ogle people, and if you like to ogle people, you're likely going to do it in the future.
All right, so number two, if the evidence does concern character, what character trait or traits is the plaintiff likely trying to prove, or is Mullen's general character at issue? So they're trying to prove that he's makes lascivious comments and makes passes
Right?
regularly, routinely against women in the street. Is that sufficient?
Okay, so what do we think? It's kind of a stretch, right, to say, well, just because he likes to ogle women, he's more likely to touch in particular, right? Especially because like ogling women on the street, he's more likely to touch this woman at the workplace.
Yeah.
And that's kind of a stretch both ways, right? Because looking is a lot different than touching. And looking at somebody on the street is a lot different from touching somebody in your workplace. To the extent the claim is he was looking at her like a piece of meat, that's a little more helpful, right? Because if you're gonna ogle women on the street, maybe you're doing it in the office, that's a little closer, right? But it's still kind of, there's no evidence that he ever leered at this woman on the street.
Or that he's done anything else at work with
Right.
another employee.
What about the language in there about he does it every time? What does that sound like? Habit, right? Routines of business, ordinary routines of business, habits, individuals. He does it every time. So to the extent that that's habit, what is that not? It's not character evidence, right?
Yeah.
Because we treat habit evidence different from character evidence. Character evidence you can introduce specific instances. Habit you can. Habits like all the time.
So you would be able to get this on Rule 406.
You might. Just be aware that that's a potential issue, okay? All right, next question.
3, for what purpose or purposes might the plaintiff want to offer this evidence of Mullen's behavior in her case in chief at trial? Why?
Sort of, we went over this, right? I mean, that's we've kind of answered that by the way we answered the first two questions, right? You might want to offer it to prove he does it all the time. He's an ogler, so he's just kind of a creepy guy, whatever.
Okay, so 4, what if Mullen took the stand and denied that he committed the acts on which the plaintiff bases her sexual harassment claim? Would that change the purposes for which the evidence might be offended by the plaintiff in cross-examining Mullen or on rebuttal? How? What if he testified simply that he has never harassed a woman in his life?
We're kind of getting to impeachment, which we didn't say we were going to do, right?
Yeah. So if he denied it, could you then bring in character evidence to impeach him?
Yeah, you could bring in specific evidence, and we'll get to that actually later. And notice that there's a difference if he gets on the witness stand and said, "I never ogled her," right? Then you can't introduce evidence that he ogled somebody else to contradict the I never ogled her, right? Different thing. Okay. All right. Number 5.
Right, if a character trait is involved, what sort of evidence might the plaintiff want to use to prove that character in addition to the acts of ogling noted above? What witnesses should the plaintiff call to the stand? I would say other,
So in addition to the act, right?
okay, so a mental propensity, but how so?
Okay, think of it this way. In addition to specific act evidence, what might you offer? Reputation
Opinion and
and
reputation.
opinion. So who would you call to offer that kind of evidence?
People that know him from the community. For his
People that know him for a long time,
Yeah.
and people that know what the community thinks about him, right? Okay. And then, of course, like, what's the relevant community, right? Is it just everybody in town? Is it a specific group? Because we heard about, yeah.
That's
So,
right. How about former employees?
yeah,
Is that fair?
a former employee, sure. Would they have, what would they be able to talk about? Reputation among the other people at work, right?
Yeah.
Everybody knows he's a real ogler or has a reputation for touching women, right? Or you worked with him for 20 years. You're retired now. What's your opinion of his character for ogling, right? So besides the specific acts, you can offer reputation or opinion, and then who's going to be qualified to offer an opinion?
Anybody that knows him well.
Somebody who's known him long enough to be able to observe it. Who's going to be able to testify to reputation? Somebody who knows the community,
The community, yeah.
right?
And what their opinion
Yeah,
is of him.
exactly.
All right. What is the likely impact of each of these sorts of evidence on the jury, and is that impact unfair?
And get rid of all the specific rules. Might the defense argue for, keep it out under Rule 403, and how and why?
Well, is its probative value substantially outweighed by the unfair prejudice, or is it undue prejudice?
Right.
In this particular case, I think it's unfair prejudice outweighs its probative value because, like we talked about earlier, this was on the streets as opposed to being in.
Okay, so if we're talking about he does it all the time when he sees women on the street, why is that probative value? How do you assess that probative value to he's ogling her in the workplace, he's touching her in the workplace?
Well, if he has a known reputation for ogling other women, it is more likely that he would ogle this particular woman.
Okay, but
So that's the probative
ogling
value.
people on the street has some probative value does he do it to employees generally? But maybe not a lot.
Not a lot in my opinion, because they're two different situations. How you conduct yourself on your personal time out on the streets is a lot different than how you conduct yourself in the workplace.
With somebody who you know, right? It's not some impersonal, hey, I just saw that woman walk by. It's, this is Judy. I work with Judy.
And the
Okay.
unfair prejudice that comes along with that substantially outweighs the probative value.
And why is that?
Because a jury is more likely to think, if this evidence is introduced, that he's a perv, so they may act on emotions.
Yep. He's a
He's a perv. He does it once, he does it every time.
Yep. Yeah. everybody see why that sort of ogling on the street maybe has a Rule 403 problem? At least to the extent it's trying to prove that he touched her in the workplace, right?
Yeah.
A little more probative value to the extent she says he's always looking at me like a piece of meat, you know? Okay, so Rule 403, and again, remember with Rule 403, context is everything. Context is everything for the Rule 403 objection. So what other evidence have you got? How does this evidence fit with it? Is this kind of cumulative? Is the jury likely to consider this evidence for an improper purpose, even if the judge tells them not to? Right? If you introduce that evidence of ogling on the street, well, it's supposed to be probative on the issue of did he ogle in the workplace, but the jury thinks, well, I'm considering about whether he's just a bad dude who, you know, treats women improperly all the time, right? Confusing the issues might be an argument. And of course, to the extent that this is going to require cross-examining a half a dozen people about his knowledge, about the reputation in the community or whatever, then that's a whole different analysis, right?
Right.
For
If the-
403.
If the specific facts of the case that was happening, he was on trial for right now was him ogling at a woman or touching a woman in the street, it would be a lot more probative
Yeah.
than it was if it was in the
Yeah, right. If you're just going up and grabbing somebody, well, shoot, if you grab somebody on the street, actually, I think you're probably more likely to grab somebody in your office, right? I don't know. So anyway, okay.
All right. So 7, as a matter of good policy, should any of this evidence be admissible if Nolan were charged with assault arising out of his punching a male coworker in the face instead of sexual harassment?
Ooh, what do we think there?
No, it shouldn't be because, well, there would be a 403 issue again, but it would be, your probative value even goes
A lot less.
less down,
Right.
yeah. And it was already,
Because there's no like sexual element.
right.
So the fact that he acts in a creepy way
Has nothing
is
to do
less
with-
probative on the issue of, hey, he punched the dude. I mean, I'm assuming there's not a sexual element. They don't really. Punching a male coworker. Doesn't sound like there's a sexual element there. If there is, I don't want to know about it. Spanking maybe, okay, and never mind. So the probative value of, well, the ogling, I mean, that's like of no probative value, or
Yeah.
really, really little. Somebody who's not willing to abide by societal norms is more likely to be willing to punch somebody. Okay, well, yeah, maybe that's technically relevant, but it sure has really little probative value. And obviously there's an undue prejudice because people are going to be like, oh, he's creepy. So if they're responding, oh, he's creepy, you know you got a 403 problem, right? It's not, but what about, let's see, we got, but on the other hand, that sounds a little like the same, right? Because on the one hand, you've got the woman who claims, you know, he broke me in the workplace. And the other one, well, you're like you're physically touching another employee. Yeah, that's not really the same.
No,
All right. Anybody think that's similar enough that you could get it in the face of a 403 objection?
you take out the sexual part of it, the aspect of it, and really the probative.
Yeah,
value
and it's
goes
not
away.
really, then it's just, hey, he's creepy.
Yeah.
And that's not real helpful. And it
Quite determined if he's a violent
Right.
person. Okay. So 8, do you need any additional information to answer any of the above questions? Why, how, and why might that additional information alter your answers to the above questions? Maybe that you don't particularly need it, but I don't know if it says that he had ogled her at any point in the past before that. That might be useful.
Yeah, or kind of more basic, right? We were talking about if you want to introduce reputation evidence, yeah, I'd like to know what witness is being called and how they know. right? Because they don't really tell us anything about that. Or if you're offering someone with an opinion, how long did they work there? We sort of talked about this by adding some facts in, didn't we?
Yeah.
So those are the kind of things you'd like to know. You really, you don't have to go much farther than that to say, okay, I'd like to know if you're calling an opinion, a witness who's going to talk about their reputation, how does that person know the community? How does that person know about this person in the community? If you're calling somebody who's going to offer their opinion, how long do they know the person? Do they have any, right? So that information would be helpful. And then, we've sort of actually talked about the character rules already. Right? None of this is admissible under a whole bunch of those exceptions because they only apply to criminal cases, right? Maybe you say, well, it's admissible because his character is an issue. Is it really? Is his character an issue? No. What's the issue is, did he ogle people and touch people? So character really isn't an issue. Intent, motive, maybe it comes in to show motive because he's just like a creepy dude who likes to make whatever.
Passes at every go.
Maybe. I don't know. That's definitely a bit of a stretch, and then you start running into a big 403 problem. Yes.
But could you argue that perversion is a character trait?
You could try, but it's kind of squishy, isn't it?
Because I think it is.
Okay.
It seems like it could be to me. I mean,
Yeah.
you know.
So how do you define
And do you only apply to men?
Of course.
it? Yeah, one man can be perverse. Yeah.
You can apply both ways.
No, I mean, you can apply both sides of course, but it seems to me like it is a character issue.
Okay, so you'd say, look, he has a character for being a perv.
Yeah.
What does that mean? That he does pervy things, like ogling women and making smart aleck remarks. And if somebody's going to do that, well, then are they more likely to, oh, no, we can't introduce it for that, right? Can't say that he did it on this occasion. He did it on specific occasions to the employee because he has a reputation for being, because he did it on specific occasions, okay? So, and the character evidence, so how are we going to get that in? Yeah, go ahead.
Well, if you want to introduce evidence for motive, can you say it's like that he had a discussion with so-and-so coworker about wanting to get together with the victim
Do we have that?
for reducing motive?
Yeah, do we have any evidence like that?
No, I'm saying it's.
So we're making up new
the ex-
facts.
No, the
Let's
extra
talk
stuff.
about the facts that they gave us, right? He ogles women on the street, makes remarks about them. Okay, so let's look at that, right? Go back and look at 404. We can't use it to prove that he acted on a particular occasion. We're not talking about a criminal case. We're not talking crimes, wrongs, or other acts, okay? Back to the criminal case. So we're having a hard, I think we're having a hard time getting that character evidence in. Unless we say, well, we're not offering it as character evidence. We're offering it
The truth.
to show it's his habit.
Knows that.
Right. He always does it. Yeah, maybe. I don't know. It's kind of tough because all of these rules are talking about getting it in criminal cases and not really getting it in civil cases, right? Okay, let's skip the next couple of questions and go to 5.8. He wants to do 5.8. Anybody? All right.
Alright, let's see. The warden cross-examined. John Quinn, a prison inmate, is charged with assaulting another inmate. The prison warden, Warden Jameson, was permitted to testify on the defendant's behalf that, in his opinion, Quinn is a peaceful person and Quinn has a reputation in the prison community as a peaceful person. Should the prosecution be permitted, despite defense objections, to ask the following questions on cross-examination? 1. Wasn't Quinn written up twice for starting fights in the mess hall? Wow. Would it be in admitting, this evidence would be to prove acts, so this would be hard, right?
I don't know. The warden testified that Quinn's a peaceful person. That's his opinion.
Mm-hmm.
And he has a reputation as a peaceful person. So let's go back. How can you cross-examine somebody who offers those opinions, right? Right, because what we're talking about is on cross-examination. Wasn't he written up for starting fights in the mess hall? Okay. So 405A, on cross-examination of a character witness, what?
The court may allow inquiry into relevant specific instances of a person's conduct.
Okay, so is this relevant specific instances of the person's conduct?
Yes, because it would be in direct opposition to what they said, that he was a peaceful person.
Because he started fights,
Mhm.
right? On the other hand, he's written up, isn't that more like was that adjudicated, or was this more like a ticket without like proof that he would, right? So you want to know, what does it mean to be written up? Is that like an accusation that has to get proven later, or is it evidence that you actually did it, right? Okay, next.
Didn't Quinn severely beat his cellmate when first admitted to the prison 5 years ago?
Okay, so that responds to it's my opinion, he's a peaceful person. Really?
That'd be the same rule.
Okay, so the rule says the court may allow relevant specific instances of a person's conduct. Okay, beating his cellmate 5 years ago. Does it matter what happened 5 years ago? No, a long time ago. What do you think?
Yes, because it was a long time ago. Doesn't really give you a frame, but 5 years ago could be someone could be
5 years ago is a
recent.
while. And he's being charged with what?
Assaulting another inmate. So.
Ooh, that sounds an awful lot like beating a cellmate.
Mm-hmm.
So how does that play?
It would be admitted
Because what, right? On cross-examination, right? Because what?
because it's to prove a specific instance, but not as another act, but
That's
to
okay
counter
for
the-
cross-examination, right? Are you, if you're offering your opinion, were you aware that he was beating up, that he beat up another inmate? Would that change your opinion if you knew that? Right? Anybody see another objection to that?
403.
403, yes, absolutely. So what's your 403 objection?
Well, you would say that it's essentially, the probative value is substantially outweighed by undue prejudice.
So what's the probative value?
To prove that he would be not predisposed, but he's done it before, so he's likely to do it again.
No, that's not why it's being offered. Right?
Show that he's
Why is it
likely-
being offered? In cross-examination of the word.
Oh, to show that he's not a peaceful person.
To show that that warden's opinion is wrong, or to show the reputation isn't true. Okay. So, does that got some probative value?
Yes.
Yeah. Okay. Does the fact that it's 5 years before, people change, in theory, they're supposed to change when they're in prison, they're supposed to learn from their mistakes. What's the other thing that you balance with that probative value?
That the jury would say like, oh, he's done it before. He did it.
Okay, so unfair prejudice. Unfair because they're hearing about assaulting another inmate, right? Unfair because
They're gonna be judging him on the previous.
unfair because it might confuse the issues. You're admitting it to test the depth or whatever of the opinion or the reputation evidence, but the jury's not going to consider it for that. They're going to say he did it once, he'll do it again, right?
Yeah.
So maybe also confusing the jury. Maybe. So everybody see how you can make two different, basically 403, complementary 403 objections? Sure, it's got some probative value that's diminished because it's old, but there's unfair prejudice because it's the same offense, because the jury's going to confuse the issues by considering it for the wrong reason. Am I missing any 403 objections? Anybody consider? Okay. So, one, always be thinking 403, right? But two, you can see that 403 covers multiple things. And it's not it always has to be unfair prejudice. Sure, it can be unfair prejudice, but it could be also confusing issues, right? And to the extent that there's a dispute about whether he beat up the cellmate or whatever, maybe there's undue consumption of time. Okay, next.
Wait, I have one question.
Yeah.
How do you prevent, say if it's not as, or that confusing to the jury to see the different reasons why, how this should be inadmissible for one reason, but we're admitting it for this reason. Instead of saying that it's confusing the jury, couldn't you say that you're just exposing them? So in this case, you're just exposing them to the fact that they're going to say, oh, he did it once, he'll do it again. They might not confuse that with the other issue. They might be able to differentiate the two, but because they were exposed to that first issue, why we should keep it out, that they'll just, I guess I'm
Explain to me how that's different from unfair prejudice or confusing the jury.
Well, I guess for unfair prejudice.
Yeah, it's kind of an unfair prejudice thing, right?
Yeah, it's not really. I'm saying if it's
Even
not,
if they kept it straight and they said, we're only supposed to consider it for this other thing,
once
they're
they're
going to be thinking of that.
okay.
And there's going to be unfair prejudice. All right, next.
Doesn't Quinn have a reputation as a vicious man whom other inmates fear?
Okay, so is that responsive to the testimony that Jameson offered? You bet.
I mean, it is because.
Yeah,
other
he's a
people fear
peaceful
him.
person. He's a peaceful person, really? Because the other inmates think he's vicious and they're afraid of him. Right?
So what would be the rule that you would write? You think just counter the,
I'm sorry?
what rule would you cite in saying, yes, it goes in because it goes against what he testified?
Well,
Would it just all be under 405A?
okay, so the defense offered evidence of his reputation for being a peaceful person, right?
Mm-hmm.
So then what could how can the prosecution respond?
Oh, really, other people think he's vicious?
Okay, let's look at 404A2. What have we got? The defendant may offer evidence of the defendant's pertinent trait. Right? What's that? He's a peaceful guy. So the prosecution can do what?
Prove that he's not.
Rebut it. Absolutely. Oh yeah? Well, he's got a reputation for being a vicious guy. Right? So I think that's classic 404A2A. Right? What about 4?
Doesn't Quinn have a reputation for involvement in failed prison escapes, so there was never enough evidence to prosecute him?
Okay, how would we get that? Well, first of all, anybody gonna object to that?
Yes.
Okay, if you're an objector, what's your objection?
That it's irrelevant
Okay, why is it irrelevant?
because we're trying to decide if he's a peaceful person.
Yeah, what does this have to do with being a peaceful person?
Just so he's trying to escape doesn't have anything to do with how peaceful he is.
Yeah, but people who try to escape are more likely to do other bad stuff. Really? Yeah, I don't know. Yeah, that doesn't really relate to, it's not rebutting he's a peaceful person, right? Not at all, I think. And Quinn has a reputation in the prison community as a peaceful person. So it doesn't really relate to either the opinion or the reputation, does it?
Could you bring a 403 as well?
Sure, and what would you say?
That its probative value is substantially outweighed by the undue prejudice because there's little, if no, probative value because his failed prison escape attempts has nothing to do with whether or not he's a peaceful person.
Okay. And what, is there likely to be unfair prejudice if the jury hears that he's tried to escape?
It would confuse the jury.
What about unfair prejudice? Let's talk about that for a second.
Yes.
So not very high probative value. Undue prejudice? Well, sure, because your natural reaction is, crap, we gotta keep this guy locked up, he's trying to escape. Right? Right?
Yeah.
I mean, does anybody think that that's not an unfair prejudice? I mean, what he's accused of is assaulting another inmate. It wouldn't most jurors go, lock that dude up in a higher security thing. We gotta keep him in because he's trying to get out. And that isn't what he's accused of. Right?
He was accused of breaking the law, and now he's trying to break the law by.
Well, that's a pretty general description, right? He's not accused of trying to get out of jail.
But if that evidence is admitted, he would be, right?
If you add to the question, he's not accused of trying to break out of jail.
Yeah, no, he's not accused, but it would.
In fact, the question tells us there isn't enough evidence to charge him with breaking out of jail.
No, I know. I'm not saying he's being accused of that, but I'm saying it would be unfair prejudice because the jury would be exposed to that.
Yes, exactly. So here it's unfair in a number of, it's not probative in a whole bunch of ways. One, because it doesn't really relate to he's a peaceful person who wouldn't beat the crap out of somebody. No, doesn't really relate to that. Two, we know there's not a whole lot of evidence because the prison authorities decided they didn't have enough to actually, prosecute it for. So there's a question about if you mention it, well, there's not even enough proof to charge him for it. And three, you've got that significant undue prejudice of your sort of natural reaction to hearing a guy want to escape is put him in a deeper hole, right? Okay, all right, good job. Group therapy. No questions. Who wants to do that? I mean, none of the like break it out kind of questions. Okay.
Okay. The psychiatrist who's been treating a prison inmate, Johnny Barrow, who is now charged with assault, is called to the stand by the defense to testify that Barrow is peaceful. Can the prosecution properly ask the psychiatrist on cross, didn't Mr. Barrow assault another patient in a group therapy session under your care?
Okay. Assume that we're not talking about a privilege issue, right?
Okay.
So let's set that objection aside. Okay.
I would say, yes, it could be offered as.
Okay, what rule are we looking for?
What rule? The character, you mean 403 or character evidence?
I don't know. What rule are we looking for?
We're looking under the criminal aspect of the peaceful. If the defense is offering it as peaceful, the prosecution would say he assaulted another patient, which would prove he's not peaceful. so therefore it can be offered as evidence, as character evidence.
Okay, so, on so rule 405A, what can you do?
You can offer it as opinion.
No, 405A, toward the end, right? What do we got here?
Oh, of course.
This is cross-examination,
The
right?
court may allow inquiry into relevant specific instances of the person's conduct.
So,
Okay.
the defense calls the psychiatrist
Mhm.
to testify to what?
The-
Johnny is a peaceful guy.
Yeah,
So on cross-examination, what can you do?
you can,
The court may allow inquiry into relevant specific incidents of the person's conduct. Anybody think it would not be relevant to ask about attacking another guy in group therapy?
yeah.
So it sounds relevant.
It sounds relevant. I think it passed the 403 test.
Yeah, well, even setting aside the 403 thing.
Yeah.
It certainly meets 405A, right?
Right.
So 405A, the defense has offered evidence of peacefulness, and in cross-examining that evidence witness, that character witness, the court may allow inquiry into relevant specific incidents. Like, he ain't so peaceful, he attacked a guy in group therapy. Okay.
Okay.
All right. Rule 510. Anybody?
The defendant is charged with attempted homicide on a victim named Margie Olares. The defendant claims self-defense, arguing that Olares was the first aggressor. To support this claim, the defense offered evidence that the victim was a violent person. Can prosecution offer evidence that the victim, Margie Olares, had a reputation among students in her nighttime GED program as a peaceful woman?
Okay, so let's go back and look at the rule, right? Exceptions for a defendant or victim in a criminal case. Rule 404A to C, right? Because we know this is a homicide case, right? Or is it a homicide case? It's an attempted homicide case.
Right.
So maybe the homicide rule doesn't apply, right? Let's assume the homicide rule doesn't apply because it's not homicide, it's only attempted. Okay, so under the general rule, right? The defendant claims self-defense. And
442.
so the defendant offered evidence of an alleged victim's pertinent trait, violence, right?
Yes.
And it's admitted, so what can the prosecutor do?
They provide evidence to rebut that.
Okay, so what would that be? Reputation evidence of the victim's pertinent trait, right?
Right.
So the evidence is he's the first aggressor. Okay, and so in response, the defense wants to, the defense offers evidence that the victim was a violent person. Now, in cross-examining, can the prosecution offer evidence that the victim had a reputation as a peaceful woman? What do we think? 404A to B. The defendant may offer evidence of an alleged victim's pertinent trait. Okay? Violent person. All right, that's what they did. If it's admitted, what can the prosecutor do?
We'll offer evidence to rebut it.
Okay, there's a reputation among students in her nighttime GED program as a peaceful woman. Rebut evidence that she's a violent person.
Well, it's quoted because it shows the character that she's a peaceful woman, and she would not likely be.
So how does that fit in this rule? A defendant may offer evidence of an alleged victim's pertinent trait. Done.
Right.
And if the evidence is admitted, the prosecutor may what?
offer evidence.
offer evidence to rebut it. So does this reputation as a peaceful woman among students of the nighttime GD program rebut the evidence that she's violent or that the victim's violent?
Yes.
Yeah. Does it matter that it's among this select community of GED students? Anybody? What do we think?
It's among people saying that she's not.
Those are people that would know her, right? Is that the relevant community?
That's
Well,
their opinion.
Yeah, I guess. I mean, they're rather specific, right? Not the community at large, the nighttime GED program. What do you think? Is that, if anybody think that's not the relevant community?
Seems isolated, but still certain communities saying it.
Okay, probably they're gonna, it's not where she works, it's not the neighborhood she lives in. That'd be more helpful. But it's a place where people get to know each other. So they probably know enough about her to offer an opinion, you think? Or not? Anybody think they don't know her well enough? Come on.
I think they do, because, we're in a nighttime
Yeah.
program.
Yeah, you probably got to know each other. Okay. Can you see why it'd be better if it was, she had a reputation among people in her neighborhood or among the people that she worked with?
It's a longer time span.
Yeah, they know her better, right? And probably, and like you say, how long is she in this GED program anyway? I mean, let's hope it's not that long. Right? Okay, so if it's a relevant community, it's got to be people that know you for long enough and in a context that they can offer an opinion that's helpful. Okay, number 2.
Was, in the opinion of her coworkers at McDonald's, a peaceful woman?
Okay,
It's
is that an appropriate community?
it's more appropriate because they see her interacting with coworkers and customers and more varied individuals.
Yeah, because you could see her interacting with a variety of people. Yeah, okay. So it used to be long ago, the relevant community was where you lived, right? And that's kind of gotten expanded so that we can offer evidence from other situations or other places. Okay. What about number 3?
Despite being punched 3 times in the face by a neighbor, had never defended herself or retaliated with violence. It's even
What's
more-
wrong with this?
It's a specific instance.
Specific instance to prove a character trait, right? So it's the way it's being elicited, right? You'd have to, you probably have a hard time introducing that. Maybe if you somehow were introducing it in cross-examination of a character witness, maybe, but it's going to be hard to do that, isn't it? How's this character witness going to, anyway. So recognize that it's specific act evidence, so that could be a lot harder to get. Okay. Let's see. 5:12.
Okay, Jim Rambo was known around town as a one-man terrorist gang. He had burned down the town hall, shot 3 different people in the leg, and participated in 24 separate bar fights. One hot and dusty June day, Perry, the owner of Perry's Grocery, hired Rambo to serve as a security guard for the store. Perry gave Rambo a low-caliber pistol to carry while on duty. During his 5th day on the job, Rambo got into a fight with one of the customers and shot him. The customer brought suit against Perry, claiming negligent hiring. Plaintiff's first witness is the mayor of the town. The mayor will testify that, in his opinion, Rambo is extremely dangerous, if not lethal. he will also recount all the prior incidents involving Rambo's harmful behavior. Which part of the mayor's testimony, if any, are admissible?
Okay,
I would say just the first part, because his opinion is that he's extremely dangerous.
okay,
The second part, he's talking about a specific incident.
right, so what's the issue here, right?
It's his character that they're,
Isn't the issue, does the store owner know that he's hiring a dangerous person?
that's true.
Right, let's assume that there's plenty of evidence that he actually like shot the dude,
Okay.
right? So we're not offering evidence that, hey, he's a bad guy, one-man terrorist or whatever,
Okay,
as evidence that he shot the guy, okay? So let's sort of take the, did he do it off the table?
off table, okay,
If we do that, then we're kind of focusing on, did the owner, did Perry know about Rambo's dangerousness, right? And if that's the issue, then what have we got? We've got opinion that he's extremely dangerous. Admissible? How does that relate to whether the store owner knew? Anybody?
I'm on the fence, I would say no, it's not admissible.
Yeah, and why not?
Because we're talking about Rambo, not trying to focus on.
There's no information that just because the mayor thinks Rambo's an extremely dangerous guy, that somehow the store owner is supposed to know about it, right?
Right,
Because notice what this isn't, the first thing. It's not reputation. Now, sure, the mayor would be a great person for reputation, because presumably the mayor knows everybody and would be really acquainted with the reputation community. But that first piece of evidence isn't reputation, right? It's opinion about Rambo's dangerousness. Really low probative value, if any, that the store owner would have also known about the dangerousness. Okay, what else have we got? Recount all the prior incidents.
yeah.
Okay, that gonna be admissible?
I would say no. It's not. It
Yeah.
would be admissible. They're still focusing on Rambo, not based on what the store owner.
Maybe if these specific incidents are just so widespread that everybody knows, right, that Rambo burned down the town hall, shot 3 different people, and was in 24 bar fights. Yeah,
In addition to the 403 issues on this, is this a trick question because it's a civil action and the exceptions apply?
yeah, but so far we haven't. So far we're talking about, we're not talking about character evidence, right? Because we're not talking about evidence that's being offered to prove that Rambo acted in a particular fashion on a particular day, right?
Yeah, you're right.
Right, so we're not, so really in a sense, yes, it sounds like character evidence,
Right.
but it's not offered as character evidence, right? So if you look at a 404B, right? Evidence of a crime, wrong, or other act is not admissible to prove a person's character. Okay, so we're not offering it to, show that Rambo acted on a particular occasion, acted in accordance with the character. Instead, it's 404B2. The evidence may be admissible for another purpose. What's the other purpose? What's the other purpose? The store Perry knew about his dangerousness, right? So it is admissible for another purpose. Evidence of specific act evidence is admissible for another purpose, right? Isn't that what that says? Evidence of a crime, wrong, or other act is not admissible to prove that they acted in accordance. This evidence may be admissible for another purpose. Okay, so go back and look at this. Okay, what have we got? We've got, you'll also recount all the prior incidents. Admissible? Well, they don't really violate 404HB2. because they are admissible for another purpose. But wouldn't you have to somehow tie it up? And these other acts are so notorious or so widely known, I mean, they're like really bad, they're on the front page of the newspaper and everything, that Perry would know about them. Right, so we don't know how notorious these things are. But it sure sounds like some were pretty bad, like burning down that town hall and shooting people. Yeah, Perry probably knows about that. Okay, but that's the key thing, right? Perry's knowledge. Okay. Well, what about when the mayor testifies he's got a reputation as a one-man terrorist gang, right? They don't tell us that the mayor testified to that, but they say he's got that reputation, so presumably the mayor knows about it, right? If that's the reputation in the community, there's some probative value because the owners in the community probably knows about that reputation. So he knows he's a bad guy, okay? So what this problem is illustrating is what's the evidence being offered for? So a couple things. What's it being offered for? What's the purpose? The purpose is to show, did the owner know that he was a bad dude, right? So it sounds like character evidence because the mayor's talking about his reputation. The mayor's talking about specific bad acts. The mayor's saying he's got a reputation for being dangerous. All of that sounds like character evidence. Do we all see why it's not character evidence? Because it's not being offered to prove he's a bad guy and therefore he did bad stuff. It's offered to prove the owner should have known or knew or did know that he was a bad dude. Okay? Anybody have any questions about that? Because this is like a really key idea. It sounds like character evidence, but it's really not. We're talking about reputation. We're talking about specific acts. Man, that sounds a lot like character evidence, but it's really being offered for another purpose entirely. Yes.
Just to clarify, so with the exception for negligent hiring, it's only permissible to prove that he was bad character. But in this instance, they're asking, did the owner know? That's why it's not admissible.
No, it is admissible. It is admissible to show the owner knew.
Oh, okay.
Right?
Yes.
Because it's not being offered to prove he had this character and so he shot this customer, right? We're sort of presuming that there's plenty of evidence of other people in the store go, hey, I saw the dude shoot the customer, right? So it's not being offered for that. It's being offered to show another purpose, knowledge by the store owner. And because of that, Rule 404AB1 or AB2 seems to say you can offer specific act evidence to show for another purpose, like to show knowledge. Okay?
So if this were a criminal act instead, and it was to show his, his prior acts.
Yeah, so if he's getting prosecuted for shooting
somebody, this would be, well, it may be admissible on other grounds, but not for that purpose.
Right, because we're not offering it for that purpose. But I'm not sure I followed your question. Suppose we rewrite the question and he is being prosecuted for shooting?
Yeah, say it's a criminal act, essentially, he's being prosecuted for shooting, yeah.
So let's think about that. First, we know that specific act evidence isn't admissible to prove character in order to show that he acted in accordance with that character, right? So 404B1 can't use it to show that he shot the guy on this particular occasion.
Yeah, I'm looking at B2 trying to find a different way that I could possibly get it, but I can't.
Well, you could show maybe he had a motive. I don't know.
With the specific act that happened prior to this incident, though.
Yeah.
Could you show a motive with that?
I mean, if you're maybe you offer evidence about him shooting the other three guys because you can say, look, he's familiar with firearms and he knows how they work.
This wasn't an accident.
Yeah.
Yeah.
Right. Maybe that fits.
Maybe, yeah.
Okay.
And then you have the 403 issue too.
Absolutely. Right. Now, the 403 issue, let's talk about the 403 objection as it relates to the knowledge of the store owner. Okay? What do we think? Introducing all this stuff about he's a one-man terrorist gang, he burned down City Hall, he shot 3 guys, 24 bar fights. What do we think? 403 objection, man. If you're the store owner, you're like, oh geez, I gotta get that evidence out. That makes it. How could I not know?
So I think its probative value is high.
Why is that?
Because all of these acts are so notorious that it shows that he should have
You
knowledge
bet.
of it. But
Right?
at the same time, it's obviously extremely.
What's the undue prejudice? Why is it unfairly prejudicial?
Because the jury will certainly act on emotion when they hear that he's shot 3 guys.
Yeah, but we don't care about. It's not being offered against him. It's being offered against the store owner. Where's the unfair prejudice there?
That's what, yeah.
Right? Is the jury going to react emotionally and say, "That's a miserable son of a bitch. We got to punish somebody. So let's nail the store owner." Right? Maybe. I mean, if you were trying to keep it out, you'd certainly try that. Right? Say, look, if you let in all this evidence about what a horrible dude he is, the jury's going to be looking to punish somebody, and the only target is the poor store owner. Not crazy, maybe not persuasive, but not crazy, right? At least maybe it gets you some of the evidence cut down. And by the way, what would another 403 objection be? Cumulativeness, undue consumption of time. Do we really need to hear about 24 bar fights? Right? Okay. Yeah, really good to follow up with the 403. Of course. But again, when we were talking about 403, what did we say? It's always in context. You always have to look at the context. What's it being offered for? Who's it being offered against? What's the other evidence in the case? So, okay, let's do a couple more, because I am fading fast here. It's not nearly as bad as it was yesterday. I mean, literally, I got home from the dentist and took the pain medication and went to bed. And I got up a little later and ate something on the other side and went back to bed. So it's not nearly as bad as it was yesterday, but I am kind of losing my energy. Okay, let's try problem 516. Okay. Wait a minute, that's not working. Because that talks about 512, but we didn't. Oh, we did do 512. Yeah. Okay, so we got items 1, 2, and 3 in 512. Okay. First of all, Rambo's extremely dangerous and not. 1, 2, 3. Where 1, 2, 3. Okay, 1, he's known as a one-man terrorist gang. 2, the opinion of the mayor that Rambo is extremely dangerous. And 3, the specific incidents of all that prior stuff. Okay, so if we're going to get the reputation around town in, what do we ask the mayor? You call the mayor to the stand. What are you going to ask him?
How high profile those incidents were?
Before that, we're not talking about the incidents, right? We're talking about he's known around town as a one-man terrorist gang. Mr. Mayor, are you the mayor of Indio? How long have you lived in Indio? Do you know the community? Have you campaigned around town? You know lots of people. You know what people's opinions are. You know about local people that have gotten in trouble, right? Have you ever heard of Jim Rambo before? Oh, yes. Well, what's Mr. Rambo's reputation? Objection, lack of foundation. What's the lack of foundation, right? You're the mayor. You've lived in town your entire life. You've been talking to people all over town about all sorts of things for your 10 years of being mayor and 3 years before that, okay? So that would be the foundation that you would lay to get the one-man terrorist gang reputation, okay? Would you do anything differently for the mayor's opinion? In your years as mayor and all this, Have you come to form any opinions about Jim Rambo? Oh, yes. And is that based on information that you've dealt with Mr. Rambo because he's been prosecuted by the city attorney and all this? Yeah, okay. And what's your opinion about Jim Rambo? And you can probably think of some other things that would show that he was familiar with Mr. Rambo. You've read police reports about crimes committed by Mr. Rambo. Yep. Okay. And then the third thing, the prior incidents involving all those specific acts, right? How are you going to show those? The mayor would actually have to know something about all those, right? May not have firsthand knowledge there. That could be a problem. Everybody see that? The mayor can talk about the reputation and give his opinion, but how's the mayor know about the specific acts that Rambo committed? Because somebody told him? Ooh, sounds a little bit like hearsay. Specific acts? You want to offer evidence of specific acts? You got to call a witness who has personal knowledge of what? Anybody? Specific acts, right? Do we see the difference?
What if it was like on a newspaper?
What is it? You want to testify about what you read in the newspaper? You want the mayor to testify about what he read in the newspaper, she read in the newspaper? Here's the problem. The newspaper, it's classic hearsay, right?
Okay.
Now, it may be if you want to talk about, and have you learned things about Jim Rambo? You bet. You got an opinion about him? Oh yeah. What's that opinion based on? I read all this stuff. Probably good enough, right? Reputation? Reputation goes more to knowledge yourself, but if you've had a chance to talk to people, and the mayor's probably talked to people, you got to do something about the Jim Rambo, right? You probably, based on things you've heard and conversations you've had about the community or whatever, you have a sense of what the community's opinion of Jim Rambo is. And that maybe that's one way of putting or distinguishing between what your opinion is, that's opinion evidence, and reputation, that's the community's opinion. Okay? Everybody see how that works? And if you're the mayor, you can base that on pretty much anything, conversations with people, editorials in the newspaper, whatever. But if you're going to talk about specific acts, you're probably going to have a hearsay problem. If you want to say Rambo broke up this, burned this place down on this day. And what does that lead into, by the way, 403 objection? It's taken for freaking ever. We're going to try 24 different bar fight cases. We're going to try burning down the city hall case. We're going to try the case about shooting 3 different people. That's an awful lot of, that trial is going to be an awful long trial, isn't it? Okay. All right, so.
But if he was burning down the town hall, would the mayor be involved in it, so he would have specific?
He might, we don't know. And maybe the mayor, helped investigate it and got some of the evidence. I don't know. Okay. Let's do a little bit more. The tortious criminal assailant. Okay, that sounds interesting. 517. The point of that last question was to get you thinking, not about what evidence was admissible, but how would you actually, the mechanics, how would you get it in?
I was actually thinking about the character of Rambo when I read it. I
Right.
didn't think about the owner for some reason, just
Yeah,
got
yeah.
lost in.
Right. So it's like really important to read the question, right? So,
Question,
yeah. Okay, so 517, anybody want to do that one? Come on. Who had a short one? Yeah.
All right.
Okay.
So I'll help with the answers.
Yes,
Feel free,
everybody
feel free.
Okay.
Okay.
This is a team effort.
Okay. Charlton Hestown.
Oh,
I think
come
it's
on.
like Charlton Heston.
Charlton Hestown. Really?
Charlton Heston has been civilly sued for intentional tortious assault. In this jurisdiction, that cause of action has the same elements as criminal assault, that is, attempting to cause or purposely, knowingly, or recklessly causing bodily injury to another person. Hestown calls his priest to the stand, who testifies that Hestown has a reputation as a good, kind man. Is it admissible? Why or why not?
Okay, so
First, I think
let's
it's
go back,
similar.
let's go back and look at our rule. Because here we're offering the priest, that used to be like the perfect character witness, not so much anymore, but you're calling it, right? Especially if it's a child abuse case. Okay, so you're calling the priest to the stand, who's gonna testify about what? He's got a reputation,
A good, kind man.
so, and that's being offered for what? To show he didn't do it.
Show he did not do it.
Right?
Right.
So if we look at the rule, evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character trait. Well, crap. That's not good. So it doesn't look like we can bring it in. Yeah, that's a problem. Does it matter that the civil tort lines up with a criminal case?
I think that's kind of tricky.
Yeah, it is kind of tricky, but it looks like it's probably inadmissible. Okay, number 2. Somebody else.
Yeah, somebody else. Okay.
Assumes that the priest testifies that Hestown's reputation is that of a law-abiding man. Does this change the result?
Well, what do you think?
I mean, it sounds like about the same thing.
It does,
Good
doesn't it?
man, law-abiding man.
It does.
I don't know.
And if we try to find some other reason for it, does it go to motive, opportunity, intent? No. Does it go to yeah, no. No, we're not getting it. Okay, number 3. Peaceful person? Yeah, it really doesn't matter, does it?
Wait, real quick. Law-abiding man, is that speaking more, sound like maybe a habit or no? Is it still more character?
Well, it sounds like character, because it doesn't say he always follows the law. But, maybe. Honesty?
Doesn't matter.
Yeah. That sort of really sounds like, well, he's telling the truth. Well, we're not gonna really, how does that relate to whether you're committing assault? Okay. Now, think about these things in the context of a criminal case. Suppose he's accused of the crime of that tortious assault. Okay? Well, let's go back.
Well, I think the first one.
Then, all of a sudden, some of this stuff becomes admissible, right? Why? A2A. What does it say? Defendant may offer evidence of the defendant's pertinent trait. So the question you gotta ask then is, which of these traits are pertinent to an assault charge? Good or kind person?
Yeah,
Well, kind and good, yes, Florida, maybe. How about law abiding? Yeah, well, to the extent it means he's really reluctant to break the law. Yep, yeah, that's sounding more pertinent to the assault charge. Peacefulness, wow, that's the sort of opposite of assaulting somebody. So you can see where if it's a criminal case, you may be able to get it in. Now, of course, you also open the door to the prosecution to come back at you and show that you're not in any of those things. But you also see that there's room to argue about whether a particular character trait is really relevant or pertinent to what the charge is. And the closer that, like, peacefulness sounds a lot more like, you don't hit nobody. Law-abidingness, yeah, maybe. Being a good, kind man, kind of a lot harder. Make sense? Okay. And, suppose the prosecution wants to respond by, "Now, let's get his best friend on there and talk about he's got a reputation as a drug dealer." Right? Does that matter? In the civil case, you can be able to get that in? Well, now we call it the prosecution. Okay, so let's call it a criminal case then. You gonna be able to get that in?
I would say no, because it's a relevance issue.
Okay.
It's not.
Sort of dependent, does it matter if you allow that evidence in from the priest that the defendant's law abiding?
Oh, yes.
Yeah, right?
Yeah.
During cross-examination of someone, yeah, right? But this isn't cross-examination, this is somebody else. Is this evidence of a pertinent trait? Well, yeah, if you say it's law-abiding and, okay. May offer evidence to rebut it. Like he's not law-abiding, okay? Peaceful, I don't know. Honest, if that came in, yeah, selling drugs is probably a crime of moral turpitude. So that could respond to, that could be admitted under A2A, right? The prosecutor may offer evidence to rebut. But you can also imagine a Rule 403 objection because selling drugs is a little bit worse than hitting somebody. It sounded more like planned criminal activity, like it wasn't a one-time thing. It was like you commit crimes a lot, and drugs are bad, and maybe they're hurting our kids, and and all that kind of stuff. So you might have a 403 objection. All right. Anybody want to do any more of this? What do we think?
I understand it a lot better now that we went over these.
Okay. So, in thinking about 403 stuff, did anybody come up with anything that we ought to talk about? All right. Make sure you have a good rule statement for 403, which is probative value substantially outweighed by undue prejudice or unfair prejudice, undue consumption of time, or confusing the issues. Yeah. And in that order, right? Unfair prejudice, probative value substantially outweighed by one of those things. So, all right. Thank you, everybody. I appreciate your patience with the drugged up law profession. I will be taking some more pain medication because I use my jaw a lot. All right, Professor Owen's back next week. Trying to think. I think I will be here next week. No, it's November when I'm back here. Okay. All right. So thanks, guys. If you're interested, this book, I am sure, is at the law library. And you can go into section 6. And there's a discussion of a whole bunch of California cases about the admissibility of evidence, of character evidence. And you can sort of see how the cases have kind of lined up and what the rationale is. So if you want some examples, real life examples, recognizing they're under California law, not the federal rules, so it may be a little different. But the principles are the same, and you can get some examples that you might find interesting. Okay? And it's Justice Simon's California Evidence Manual. All right? And again, you don't have to do that. It's just if you want some more examples from like real life California law, you can sort of see how it works, or at least how it's been applied by our court. Everybody sign the, yep. Not me. Guess I gotta do that. And where do we think Nolan is? Probably still in Needles, huh? Yeah, we should call him. Dude, are you on the road? All right, see you guys next week.
See you.
no, you didn't call me there, did you? Okay. No, no, it's fine.
Yeah.
It's
I'm pretty
909.
good about that.
It's like, I don't know, I feel like she goes
369.
Dude, that was like less than halfway.
It's a 5:30.
Yeah.
I hope I'm not calling you. This guy from New Jersey called and said that I called them.
Was it me?
be there.
I called you? I don't know who it was.
Please give me the.
Someone's not on my call, like, I looked at her, oh my.
Yeah, it's not really.
Was that a 909?
It was a 909.
Attorneys,
Yeah.
and essentially what it is, just
Yeah, Diamond Bar, 895-3182.
Oh,
a memorized.
Not me.
Huh?
I only know one person.
So they send us a
Is it Diamond Bar?
No, I only
a
know
letter.
Oh, okay.
exactly that.
See you later.
paper, I know it's here.
Your address and you write, regarding this case, whatever. I'll send you something. It's.
Is it about, which, was it, you told me an essay, 2016, being that you looked over. Was it 2016? It had a lot of issues in it?
Oh, that was
The
the rocket.
2017
17
Oh,
October.
2017.
October.
Yeah, 2017 October,
Okay,
a budget for it.
2017 October.
Yeah, that was
Okay,
a good
because
grade for it.
I was looking for stuff and I thought, for some reason I thought 2016 and I was like, I couldn't see it.
Did you get the files from Cy too for the?
Oh, yeah, he gave it to
He
me,
gave
yeah,
it
I
to you,
got
so
it.
everybody has it.
Everybody has it.
Good, okay, good. I
Yeah.
just wanna make sure, 'cause
Well, I'm gonna